is just about 1 o'clock Pacific time, so we're going to go ahead and get started. I want to thank everyone for joining the webinar today. My name is Mike Lindsay. I'm with ICF International. We're one of HUD's TA providers, and I'm also the regional coordinator for Region 10. I am joined today by two other TA providers. I'm joined today by Kelly Barker from APT and Irene Regallo from CSH, and both Kelly and Irene are also regional coordinators in other regions. For joining today's webinar is going to focus on increasing mobility options for homeless individuals and families with tenant-based rental assistance. Today, HUD will be talking and discussing with us amendments that have been made to the COC program interim rule to increase those mobility options for individuals and families. Just a couple reminders before we get started today. Typically, in typical fashion with our prior webinars, all participants on the phone will be muted today. We're expecting a high volume of callers today, so we'll be holding all of the lines muted today, but we do encourage you to ask questions. If you'll see in the right-hand corner of your webinar screen, you'll see a Q&A function. Please feel free to ask your questions using that Q&A function. We will facilitate and attempt to work with HUD to answer as many of those questions as possible on today's webinar. But we also encourage you, if your questions aren't answered through the webinar today, I encourage you to submit those questions to the AAQ system as well, and HUD will work to get you responses to your questions as quickly as possible. If you have any problems with the actual in hearing the webinar audio or technical difficulties in accessing the audio, we'll ask you to use the chat function, and Chantel Key from ICF International will work directly with you to address any issues that you have. So if you have any questions that you'd like to pose for today's participants, please use the Q&A function. If you have any technical problems, please use the chat function, and we will work with you to get those taken care of as quickly as possible. I want to introduce very quickly our presenters today. From HUD Headquarters, we have Brett Gagnon, who is a Senior SNAPS Program Specialist with the Office of Special Needs Assistance Programs. We also have Robert Waters, who is a SNAPS Program Specialist, also with the Office of Special Needs Assistance Programs. So at this point, I'll go ahead and pass it over to Robert, and we'll go into today's session. And again, at the end of the presentation, we will have a Q&A opportunity to follow up on any questions that were submitted, and we'll facilitate through those questions as well. Robert?
All right, thank you, Mike, and welcome everyone. So today we'll be, next slide, please. Today we'll give a quick review of the regulations surrounding tenant-based rental assistance and how this amendment applies to Section 578.51c of the interim rule. Participants on the call, once Mike mentioned, can use the dialog window at the bottom, Q&A section, if you want to ask questions, and it's my understanding that you wouldn't have to wait until the end of the call to submit those questions. So if you have anything that spurs a question, if we say anything that spurs a question, feel free to ask that. Slide. So that's, once again, that's me, Robert Waters, but the slide includes also Brett Gagnon. She's a Senior Program Specialist in the SNAPS office, and she's going to provide a little more detail on what this amendment entails. Here's a quick illustration of the dates at which the COC program interim rule was first published to the upcoming deadline for providing comments on an amended regulation. The amendment to 578.51c I'm sorry, just 1 second. So the interim rule was first published in 2012, as many of you know. The public has until August 15th to provide comments on the amendment to the rule. The amendment goes into effect on July 14th, So at that point, recipients can begin serving clients that find units outside COC's approved geographic area. So I'm going to go into a little bit more detail on this amendment and how COCs can implement this change in their communities. The interim rule was first published in 2012. The rule required that all assistance be spent within COC's geographic area. DV victims, however, were the only clients that could take tenant-based rental assistance outside of the geographic area if it was determined that the victim was at imminent risk of danger if they remained in the same geographic area. COC program interim rule was for comment in 2012. We received some very helpful comments and intuitive suggestions, and commenters in high-risk areas in particular expressed difficulty in locating affordable units within their COC's geographic area. So issued the final rule on affirmatively furthering fair housing, which emphasizes the importance of housing choice and further spurred the decision for HUD to amend the COC program interim rule before we issued the final rule for the COC program. This would allow all individuals and families receiving tenant-based rental assistance through the COC program to have the opportunity to use that assistance outside of the COC area in 2016. So we'll provide some more detail on that in the next couple slides. So here's the interim rule amendment published last month. The rules published on June 16, 2016. It amends the regulation under 578.51c of the rule, as we mentioned before, for the projects providing tenant-based assistance, but it goes into effect today, July 14, 2016. So that means program participants who are not victim of domestic violence and fleeing imminent risk harm can use their TBRA vouchers outside the COC area beginning today. So an interim rule, this will goes into effect immediately, allow the public it allows the recipients to provide the service to their clients immediately, but it also gives the public to provide comments on the changes in the interim rule before we decide to implement any changes in the final rule. So in fact, we encourage you to read the preamble of the interim rule amendment to see our reasoning behind the change and also the specific areas where we are particularly interested in your thoughts. So I'm going to kick this over to Brett and let her go into more detail of our changes and how you can implement these changes in your community.
Great. Thank you, Robert, and good afternoon, everybody. As Robert has already mentioned, this interim rule amendment, it really does two things. It provides all program participants, regardless of victim status, with the option to use their tenant-based rental assistance from their original COC outside of the COC's geographic area, so long as the recipient or subrecipient that's administering that rental assistance meet all of their regulatory and statutory requirements. I made one other small change for the allowance that was already permitted for victims of domestic violence that are at imminent risk of further violence. It allows them to use their it continues to allow them to use their tenant-based rental assistance outside of the COC's geographic area. But what it does is it releases the recipient and the subrecipient from regulatory requirements. They still have to meet their statutory requirements, but they no longer have to meet regulatory requirements. And it's our hope that in these particularly dangerous situations that gives recipients and subrecipients a little bit more flexibility in helping victims of domestic violence where they need to move to be safe. Next. We were working on the rule and the upcoming, and we should know we're going to be publishing FAQs go along with this, and this PowerPoint will also be posted to HUD Exchange. But as we were thinking about the questions that came up, one was who determines whether a program participant can use their tenant-based rental assistance outside the COC's geographic area. And the important thing is here, it's the program participant. They get to decide, but it has to be done in consultation with the recipient or the subrecipient, because the recipient or the subrecipient still has to meet their program requirements. And so if a recipient or subrecipient can't reasonably be expected to meet those requirements, then you don't have to permit the move. You can require that they use it somewhere where you can meet those requirements, or you can not permit, well, they move, but you can permit them. You don't have to allow them to take their tenant-based rental assistance with them. There's no maximum distance that they can move, so long as you can meet your regulatory and statutory requirements. They move however far they want to move. The COC, where they're moving, doesn't need to be notified of the move. In general, the recipient or subrecipient may need to work with providers in the COC where the program participant is moving to meet some of your requirements. They may also need supportive services in that geographic area. So you may have to work with some providers, but you aren't required to notify them of the move. And the COC where the program participant is moving, they do not have the authority to deny the move. They can't say, absolutely not, this person can't come into my geographic area. Next. What might come up was, how much can I pay in rent for a program participant who's using tenant-based rental assistance outside of our geographic area? And I think the short answer is you have to follow all existing regulatory requirements. But what it means is that for rental assistance, you get up to the reasonable rent for the geographic area where the unit is located. And so that means rent plus utilities that aren't included in the rent must be reasonable when compared to other comparable units where they're moving, not when compared to units in your geographic area. But an amount, when you come in for renewal in the competition, will continue to be based on the FMR amount, or if you're using actuals, on your current actual amount of the geographic area that's providing the tenant-based rental assistance. So your grant renewal amount shouldn't change except for FMR updates. You don't, if neighboring COC that's where the program participant moves, if their FMR is $600, you don't use their FMR, you use your FMR for calculating your grant amount. Next slide. And you all might want to know how many people can have living outside of your geographic area that are receiving tenant-based rental assistance from your agency at a time. And the important thing to note here is that the majority of the program participants in your project must continue to be assisted within your geographic area. So that means we interpreted that to mean that no more than 50% of the units assisted at any given time in your project may be located outside of your COC's geographic area. Two slides just go over the difference between regulatory requirements and statutory requirements. It can be a little bit confusing because a lot of the regulatory requirements have their basis in statute. So on the slides that you're looking at, these are examples of some of the regulatory requirements. We obviously can't fit them all in one slide. It includes calculating rent contributions and reviewing income. For rapid rehousing projects, it means providing monthly case management. It's conducting the annual assessment of the program participant risk needs. And as a reminder, unless you're assisting a victim of domestic violence who's taking a tenant-based rental assistance to another COC geographic area because they're at risk of harm in their current unit, you are required to meet these requirements. If you're assisting a victim of domestic violence in moving, you are not. Next slide. And it goes over some of the statutory requirements, and these are the requirements that everybody has to meet regardless of whether you're serving a victim of domestic violence or not. And you can meet these through your own employees, or you can meet them through contracts or MOUs with agencies in the community where your client is moving. These include, again, these are just some examples on the slide. If you have specific questions about whether a requirement is regulatory or statutory, feel free to ask or submit it to the AAQ. You need to continue to inspect the unit. You need to ensure that they're living in meets housing quality standards. You have to address their supportive service needs, and you ensure that the children are enrolled in school and connected to appropriate services in the community. Those are some examples of the statutory requirements. The next slide is going to open up the question and answers, but before we kick that off, I do want to cover one thing that's come up in both of the past webinars, and we had included it in the slide deck, but it's come up who HMIS get entered into, and boards is a program participant of those. So somebody is part of your project and they move to another COC's geographic area, but you're continuing to pay the rental assistance, then continue to enter them into your COC's HMIS. You continue to include them on your APR, and when your continuum does their system performance measures, you're going to be measured in your home continuum system performance. And so the bulk of our presentation, and now we're going to open it up to questions. Again, it's a really small change, but we hope it adds a lot of flexibility for communities and our participants.
Great. Thanks. Kick us off with some of the questions that have come in. Thanks for that information on HMIS and reporting. We know that did come up earlier in the week. Our first question here is, does this amendment apply to TBRA grants in the Shelter Plus Care program?
It does not share how many Shelter Plus Care grants are left out there, but it's my understanding that the Shelter Plus Care program didn't have the geographic area restriction in the same way that the Continuum of Care program did, which is why when we limited it to the COC's geographic area in the interim rule, I think it created some consternation for folks. It only applies to the COC program. If you have a Shelter Plus Care grant, we can talk about that offline and how it works.
Okay, I have a couple more questions that came in. We had one that came in earlier on the webinar asking for any differences between the regulatory requirements and the statutory requirements. You covered a bit of that in the PowerPoint itself with a couple examples there. Is there anything else that you would like to highlight, or anything else that you know folks have an interest in?
Those are the ones we could think of. I think we included a few other examples in the preamble, but those are the ones we could think of that would be most important to folks. Again, for specific questions, we're happy to consider, but off the top of my head, it could be a whole long list.
Okay, a little more clarification on if this rule applies to only HUD COC grantees or if it affects other funding streams and should affect any and every service provider within a COC geographic area.
Yep, it applies only to COC program funds. It doesn't apply to ESG. It doesn't apply to home. It doesn't apply to HOPWA. And it applies to anyone who is using COC program tenant-based rental assistance to serve an individual or family experiencing homelessness.
The next question came in asking if you could provide more detail or definition on the tenant-based rental assistance concept for the sake of this rule. This goes on to say that in the COC they have agencies who provide rapid rehousing services and agencies that provide tenant-based rental assistance, and these programs have names and eligibility criteria.
So I don't have my statute in front of me, but tenant-based rental assistance in general is the type of rental assistance where the client can choose the unit and then the client, they sign the lease with the landlord, and the agency usually has a contract with the landlord, and the client pays a portion of their income in rent, and the agency pays the remaining rent grant funds. So that's generally what tenant-based rental assistance is. In our programs, that type of assistance can exist in permanent supportive housing, factory housing, and transitional housing, but I'm not sure of any TH providers that are using it right now. So it could include your permanent supportive housing that's funded with tenant-based rental assistance. It also could include your rapid rehousing that's funded with tenant-based rental assistance. And so we talked about that 50% limit. It's going to be a lot more stable when you're providing permanent supportive housing in general, because permanent supportive housing, folks generally stay in it for a long time, and so your unit turnover is not as high. Whereas in rapid rehousing, whether or not you're at the 50% test on any given day could change quite likely depending on how long of rapid rehousing assistance you provide.
That's great. Our next question about the 50% limit, asking if people fleeing for domestic violence count in the 50% limit.
They do.
Okay, in the lines of the 50% requirement, there's another question in here to clarify regarding the requirement of no more than 50% of participants be placed outside of the county, the COC geographic region. Is that for each grant, or is that measured COC-wide at the system level?
Each grant. So I believe COC-wide, but for COCs, but not UFAs, it would be for each grant. And I think it's important, it's for the units, not the program participants, because family can vary in size, and so that would be we thought that would be a little bit more challenging to implement.
Robert, looks like we have a question here asking for a little more guidance on when programs might offer this option to clients or inform them of its existence, if it's something that is required to be included upon entrance or enrollment, or if any more information on when it should be communicated to clients.
That came up the other day, and I didn't have an answer for that, so that's something I think that we'll have to follow up on in another set of FAQs.
I had a question asking for a little bit of clarity on why this allowance is only being made available for program participants receiving tenant-based rental assistance, and why it's not also applied to leasing projects and or sponsored-based rental assistance programs.
So as Robert mentioned, we still have to go to final rule stage on the COC program interim rule, and actually we're planning to wait to make this change until we went to final rule stage, but then everything that was going on with the affirmatively furthering fair housing rule and the new VAWA rule that's going to be coming out and the new VAWA protections, it really made us feel like now was the time to get out this small amendment and make it available for this type of assistance. It doesn't mean that we can't consider it for other types, and certainly you can submit your public comments, which is for the next 30 now, because it's already been open for a month. That's something you should include in your public comment, and we're happy to consider it. But keeping the change really, really small.
Question following up on the 50% limit, looking for some clarification on exactly how the 50% is calculated. Is it 50% of funds available or of people? If you could follow up with some clarification there.
The way that we thought about it is on units. So if you, for instance, are funding 10 units, then more than 5 can be outside of your geographic area at any given time. And rapid rehousing, that can be a little bit challenging because different families need different levels of assistance, which is why we decided not to go off of money and not to go off of because households are all different sizes, so that can be harder to predict. But the number of units that you have leased up at any given time.
Right. Follow-up question, the 50% limitation. Does HUD have any guidance as to the selection of participants who can port in the event that there are more than 50% who request to move outside of the jurisdiction, with DV receiving the priority first?
We don't have any guidance yet. Part of it is we were waiting to use these webinars to see what kind of guidance we would need, so we can add this to the list and see what we can.
Keep coming in on our 50% live-in. So a follow-up question from an earlier submission about the calculation of the 50%. Is it units over the course of the contract year or at any given point in time?
The way we're interpreting it right now is at any given point in time.
Okay, well, and Rod, for taking the time to answer some questions today. It's like that covers all of the questions that were submitted. Or Robert, is there any further clarification that you'd like to provide to folks, or answer any questions you know that you've heard on other webinars that folks have had in the field?
I think the big one was the HMIS and the system performance. Remind you guys that we will make these slides available on the HUD Exchange, and we have a series of FAQs that are just about ready to be posted that will go over a lot of what we covered today. And we'll be taking all of the questions that come in through the AAQ and developing more FAQs off of that. Added. That came up is what if somebody wants to move across the country and you aren't able to accommodate that? Would HUD expect you to? Again, that if it's not reasonable, then we would not expect you to permit them to take their tenant-based rental assistance with them. There's nothing in this rule that limits transfers. So if you're unable to continue assisting them and the client really wants to move there, you can still work with another COC and transfer them to the other COC's permanent support housing program if they have a unit available. So there's nothing in this that prohibits that.
We did actually receive one additional question that came in through the chat function, and it was just to clarify again that it doesn't apply to any already existing Shelter Plus Care, tenant rental assistance programs, but then also asking if these requirements or considerations also extend to the ESG grants.
They don't, and they only apply to the COC program. They do. So Shelter Plus Care comes up a lot. Like I said, I don't think at this point that there are a lot of Shelter Plus Care grants still operating. There may be a couple that were in a hard time getting up and running right away. There may be. But if Shelter Plus Care has renewed under the COC program, it's considered COC program grant, and therefore this applies to that grant. So if you're in your 1-year renewal cycle and you're coming into the COC program, you're a COC program grant. You may still call yourself Shelter Plus Care, and I think a lot of people do, but the rule applies to you.
Brett, it seems that we have been able to address all of the questions that came in today. There weren't any additional questions that came in. So I want to thank Brett and Robert for taking the time today. Also thank Lee and Irene for today's webinar. And at this point, the resources that Brett mentioned also highlighted on your screen. Please access the HUD Exchange for additional resources. I want to thank everyone for taking the time to participate today. We'll go ahead and close the webinar for today. Thank you guys very much.